Hello, sir. We are Group A from Tutorial 3 of Media Law and Ethics. Our group has Cao Lixin, Wang Yiwen, Fatima, Sarthak, and CHONGXIANG. We have identified 5 laws that affect media freedom and the work of journalists and have proposed change to improve freedom.
Hello, I'm Yiwen. The law I propose to change is the first act in Section 7 from PPPA, which is the act give minister absolutely power to ban the circulation of publication. Take the case of IRF, which is Islamic Renaissance Front, as an example. In September and October in 2017, Ministry of Home Affairs imposed ban on 22 publications, include trade discourse on Islamic reformist thought. Court pointed that trade publications will undermine the public interest and order, but these trade publications were published as translation format, and these trade publications didn't undermine the public interest and order in other Muslim countries. Although the court has withdrawn the punishment for these trade publications 1 year later, but there are still no any change to PPPA law. So I think the first act in Section 7 from PPPA is still need to change. I propose to change the absolutely power to ban the circulation of publication to minister, change it to voting system, because I think we should hear everyone's voice and rather than minister one person's voice. And I believe after this change, the media freedom of Malaysia will be more better and more advanced. That's all.
Hello, sir. My name is Cao Lixin. I'll share with you my findings about Communication and Multimedia Act 1998 that affects media freedom and the work of journalists. This law was enacted in 1999 that provides a code of conduct, also defines responsibility for those working in the industry. Even though it has helped the industry sometime, the bills has created some overly broad content that has been used to suppress media workers for no firm reason. The case of Tashani Sukumara is a good example of how this law restricting journalist work. She is the journalist from the South China Morning Post, who is investigated under Penal Code and CMA 1998 for publishing the mass arrest of immigrants by Malaysian police in KL during the COVID-19 period. In the article, she stated that such rights prevents immigrants from being tested for COVID-19 and that are inconsistent with the government's promise made. In my opinion, the imprecise provision in Section 233 of CMA 1998 that allow police to charge and censor journalists without specific judgment, which have a significant impact on media freedom. Therefore, I suggest to enhance CMA 1998 for media freedom. Firstly, the provision in CMA should be defined more precisely, such as what exactly constitutes improper use of network facility or services. And secondly, the implementation of law requires the supervision of authoritative body to give different voices to make the reasonable judgment for different cases in different situations. That's all from me.
The case I am looking for is in relation to Section 4 of the Sedition Act. This case in 2015, 5 editors of the news website The Malaysia Insider and its parent company, The Age, were arrested by police for breaching Section 4 of the Sedition Act after publicly publishing a news story about Islamic Penal Code. Under the legal provisions of Section 4 of the Sedition Act, the freedom of the media is greatly restricted and a culture of fear has emerged in society, regardless of any medium, regardless of any job. The Malaysia police may come to your business or home, or even arrest you outright when you engage in any speech that is of public interest. In this context, the lack of support for freedom and freedom of expression in the media often results in nothing but silence. In today's digital media society, the media freedom of expression is all the more important to protect. Freedom of expression is a special right and a duty given to the media to lead society towards greater democracy. Based on this case, I propose 2 suggestions to increase the freedom of the media. Firstly, the media should be able to speak in public, talk about the Supreme Ruler and make public statements on current news. Secondly, the status of the government in the Section Act, while accepting the scrutiny of society, because the government should be an organ at the service of the people. It should be subject to the scrutiny of the media and the people.
I would like to present the Defamation Act of 1957. This act was formed to protect the reputation and image of an individual or an organization by the allegations made by media that may lower the image of an individual by making defamatory statement or faulty statement without any evidence. As a result, his business and profession is affected. One of the examples of this case is the case of Malaysian Kinky and Reuben Australian Gold Mines. In 2016, Australian Gold Mines filed a case of defamation against Malaysian Kinky regarding the several reports which were about operational utilization cylinders that were causing health issues among the people of Bukit Common villages. In 2016, the High Court of Kuala Lumpur ruled in favor of Malaysian Kinky, but in 2018, the Court of Appeal overturned the decision, saying the articles are reckless and damaging in tone. In 2021, the Federal Court also denied the application of Malaysian Kinky, resulting in Malaysian Kinky paying 200,000 ringgit on top of the 350,000 ringgit in cost and damages awarded by the Court of Appeal. The suggestions that would I like to make to enhance for media freedom in Defamation Act 1957 is to specify what kind of evidence should be provided to avoid defamation cases, because there are none as such, and even if the media provides such evidence, it is considered as faulty or default. The second suggestion I would like to make will be to imply some kind of penalty on the person who files for defamation case, because if the defendant is found not guilty, it will help to reduce faulty defamation cases and give media more freedom. Thank you.
Moving on to the Official Secrets Act of 1972. The Official Secrets Act was first officially enacted on the 1st of October, and it was enacted with the intention to preserve certain documents or information that would be considered official secrets to the government. But the legislation of the Official Secrets Act in Malaysia was considered by many to be more restrictive and limitative in the general sense, as it deprives people of their right to certain information, from accessing certain information or into spreading certain information. As such, it has caused much dissatisfaction among the public regarding their freedom of speech and freedom of media. The case that involves the Official Secrets Act, or one of the cases that involves the Official Secrets Act of 1972, would be the case of the divulging of the IMDb report by Mr. Rafizi Ramli. On March 28th, he revealed details of the Attorney General's report on the 1MDB. The scandal from this revelation of details triggered several ongoing investigations by Malaysia's Central Bank, by the Parliamentary Committee, and also the country's Auditor General, Malaysia's Anti-Graft Agency, and also the police. As such, the Mr. Rafizi was brought to the court according to the Official Secrets Act for divulging supposedly top secrets of the government, or secrets that should not be told to the audience, which shows that some information, even if it proved corruption or in such cases usage of money or other elements illegally, even such cases could be brought to court based on an act such as the Official Secrets Act, which is in its own way quite limited of its own, and stops from spreading of the free media or investigative media, specifically speaking towards the government or governmental officials or political bodies. But that will be all for our presentation today. Thank you all for listening, and have a good day.